because the defective CC of judgment has not been filed, but that has been filed on 18/10/2024 itself in the CMP. Second defect is appeal value. That is correct, my lord.
Appeal was dismissed on 22/11/2024. उसके बाद आपने क्या किया?
That has been restored.
That has been restored. उसके बाद आपने क्या किया?
नहीं, उसके बाद first time this is it. उसमें the defects which is showing by the SR, my lord.
हाँ.
All the defects have, as per my knowledge, I have removed.
Knowledge बताइए कौन-कौन सा defect remove कर?
First defect is
CC
the
of
CC of
impugned
impugned
judgment.
that has been filed on
Authenticated.
18/10/2024.
Where is it?
That is part of the CMP.
You filed it in the CMP.
My lord, actually the direction was from the honorable court that we file the for restoration. That's why we have filed the CMP. But that is the part of the record.
Which record?
For restoration of first appeal, we actually there is a provision, my lord, कि if the batch cases are filed, so only one single satisfied copy of impugned order is sufficient. But we have directed to file in each and every separate certified copy. So accordingly, we have filed in this in CMP, my lord, as per the direction of the court.
Which order? Which direction?
On 18/10/2024, that's part of the CMP, my lord. The IA is already filed with the forwarding IA, and the copy of impugned judgment has been filed. Although it was not required, because we have filed a batch case, but even though when it was directed to ordered to file separate in each and every, so we have obtained the certified copy of the impugned judgment and filed. There are altogether 24 cases have been dismissed for default for two very reasons: for the appeal value and for the filing of the CC of the impugned judgment. So in each and every, we have filed the certified copy of impugned judgment, and appeal value has also been mentioned. Clarified here. We have given the right appeal value.
Okay, certified copy, authentication fee.
That is missing. I mean, just now I have seen that.
तो ये कौन बताएगा?
ये
पूछेंगे हम आपसे.
अभी मुंशी बताया कि हमने फाइल किया था. Otherwise I was not.
Certified copy आपने उसमें फाइल कर दिया. बाकी?
And बाकी appeal value that has been given, my lord, the details how the appeal value is correct. Third is the appellant number 3 has not been made party. Appellant number 5 and 6 may be made party.
आप जाइए जो भी स्टैम्प रिपोर्टर है उसके साथ बैठ के समझिए. हम उसको बोल देते हैं फ्रेश स्टैम्प रिपोर्टिंग.
2 weeks may be given, not waived.
FA number 164 of 2018. The learned counsel for the petitioner submits that amongst the various defects, the defect to be cured, defect number 1 is regarding filing of certified copy of the impugned judgment with authentication fee of ₹10. He has submitted that by virtue of the order passed in CMP number 776 of 24, order dated 13/9/2024, passed in CMP number 776 of 2024. The certified copy of the impugned judgment has been filed, but authentication fee is yet to be paid. Considering the aforesaid submissions, the certified copy of the impugned judgment filed in CMP number 776 of 2024 through supplementary affidavit dated 17/10/2024 is directed to be placed in the records of First Appeal number 164 of 2018 and filing of the certified copy in CMP number 776 of 2024 be taken as filing of the certified copy in the present First Appeal. So far as the remaining defects, including filing of authentication fee with regard to certified copy of the impugned order is concerned, time till 27 January is granted to the appellant to remove the surviving defects.
With the help of
At this, the learned counsel has submitted that some of the defects have already been removed. For that purpose, the learned counsel for the appellant shall get in touch with the staff reporter to do the needful, and fresh office note be prepared. Post this case on 3rd of March 24 under appropriate heading. ऐसे कितने मैटर्स हैं आज बोर्ड में? आज है?
आज मेरा एक ही है, अदरवाइज
बाकी सब कितने हैं? नंबर
23 केसेस
बताइए, नंबर बताइए। सब रेस्टोर हो चुके हैं?
नहीं,
सब डीएफडी पड़े हुए हैं?
डीएफडी नहीं, ऑलरेडी the IA has been filed for restoration.
IA has been filed for restoration.
Why not? CMP has been filed for restoration. Again, there is some defects were there. For that purpose, IA has been filed. But only out of 30 cases, we have 30 batch cases of first appeal. For similar defects in all of them, the certified copy of the impugned order and the appeal value. But we have removed the defect.
आपसे पूछ रहे हैं कि कितने ऐसे फर्स्ट अपील हैं? सारे के सारे डीएफडी पड़े हुए हैं?
नहीं, उसमें 5 बिल्कुल सेम था, लेकिन वो बच गया, पता नहीं क्यों। And बाकी 24 है।
5 कौन से हैं?
5 उसमें actually right now I have not, although I have the list of the first appeals, but which one has been, which is surviving and which has been dismissed, just
इसका लिस्ट है आपके पास?
list or all the cases list has been.
ठीक है, वो बताइए।
Number I am giving my
एक
number of first
एक
appeals.
सेकंड। The learned counsel for at this the learned counsel for the appellant has submitted that altogether 30 cases,
30 cases and
including the present one, were filed. 30 first appeals were filed arising out of the same impugned judgment.
order, same.
However, some of the first appeals have been dismissed on account of non-removal of
Non-removal
defects.
of 2 pages.
The concerned appellants have taken steps for restoration of those first appeals.
I've got the list of 24 first appeals which has been dismissed.
The learned counsel has furnished the list of all the 30 cases, including the present, which are as under. वो लिस्ट दे दीजिए, सब एक साथ।
It's a handwritten man.
कोई बात नहीं, हैंडराइटिंग होने से कोई फर्क नहीं। ये जो आपका जो जिस ऑर्डर के तहत आपका डीएफडी हुआ था, उसमें तो मोस्ट ऑफ द केसेस का नंबर है, 23 केस का नंबर है उसमें, ठीक है?
24 cases. इसमें इंक्लूडिंग दिस मंथ 23 केसेस.
हाँ 23 केसेस है ना. ये ना लिस्ट इसके ऑर्डर में ना ये सारे नंबर डाल दो. और समीर जी जरा पता करेंगे कि इस लिस्ट में से इसमें है लेकिन इसके अलावा एक आध केसेस और हैं. आप इसको टाइप करा के दीजिए.
दे इसमें मेरा क्लियर था.
हाँ आप दे दीजिए, नहीं तो ऑर्डर नहीं साइन हो पाएगा फिर आपका अननेसेसरी पेंडिंग है.
कल दे दें.
देखिए आपको एक चीज़ बता रहे हैं उसका उपाय कि ये वाला जो ऑर्डर है 9/12/2020 जिसके तहत आपका केस अल्टीमेटली डीएमसी हुआ, इनमें जो केसेस हैं इसके अलावा जो केसेस हैं खाली उसका लिस्ट दे दीजिए. समझ गए?
उसमें फाइव फर्स्ट अपील है ना, वो डिसमिस ही नहीं हुआ था. तो द डायरेक्शन वाज टू फाइल द कोर्ट फीस. तो वी हैव आल्सो डिपॉजिटेड द कोर्ट फीस.
वो 5 फर्स्ट अपील कौन से हैं?
नंबर तो
ये जो है ना ये लिस्ट
हम
इसके
देखते हैं,
अलावा
हम
जो
मैच
5
करते हैं.
बच्चे होंगे वही होंगे.
जी.
इसको जो है ना आप इनको दिखा दीजिए ये वाला लिस्ट. इस लिस्ट के अलावा जो 5 केसेस या इसके अलावा जो भी केसेस होंगे वो भी आप हमको दे देंगे. तो ये वाले लिस्ट के साथ उसको भी हम लोग इसमें इंक्लूड करेंगे. ठीक है? तो आपका सीएमपी लिस्ट नहीं हो रहा है क्या?
अभी नहीं हुआ, हो जाएगा. वी जस्ट प्रायर टू क्लोजिंग हम फाइल किया था.
ठीक और इसमें एक तो डेट दे दीजिए. आपको कब तक का टाइम दिए हैं? 27
3rd मार्च. तो 27 जनवरी तो हमको करना उसका टाइम एक्सटेंड कर दिया.
टाइम क्यों एक्सटेंड कर?
ठीक है. 3rd मार्च को
हाँ पोज दिस केस ऑन 4th of February.
Item 3, second appeal 48 of 2023.
Your Lordship, I propose the defects on the last date for the office standing payment. मेरा पता चला कि court fees is deficit for rupees 7,370.
There are no other defects.
No, Your Lordship.
Essay number 48 of 2023. The learned counsel for the appellant prays for and is granted time till 10th of January
Your
25.
Lordship, longer time may be given because it's a
Bankrupt
company
हो गया है
matter.
आपका BCCL.
No, Your Lordship.
How do you
it's
do
a-
it?
It's a company matter. Your
So?
Lordship, they'll have to do a lot of formalities.
No
2
formalities.
weeks,
Let
at
it
least,
be
Your
dismissed
Lordship.
for default. Then you will understand the formalities. 10th of January 2025 to
14.
remove the surviving defects peremptory. If the defects are removed within time, post this case under appropriate heading on 15th of January.
Item 4, first appeal 251 of 2023.
Because it can be ignored also. For the address is concerned, I have already corrected, but thereafter also it has come minus. It is defect number 4 and 6 is concerned. And one is only a type copy, that is a memo of the. Can be ignored.
We will not ignore any defect in these appeals without any interlocutory application.
And only that is the defect number 1, 4 and 6 is concerned. Now that has been covered.
2 copy of page 9 may be filed. What is page 9?
Page now that is the memo with respect to the impugned order is concerned with respect to the title, first title of the it can be ignored by the sir. Otherwise I could find it in the process. आजकल मेमो आ जाता है
2 typed copy. ठीक है. Defect number 1. 4 and 6.
4 and 6 is with respect to the address. I have already corrected, and as per the impugn order or the degree and judgment is concerned, address is there.
Respondent number 2.
Respondent number प्रियंका पांडे.
Respondent number 2 की बात कर रहे हैं. Respondent number 1. श्रीमती
उसमें एक
प्रियंका
कलम
पांडे.
छूट गया था, वो उसको तो पेन से लिख दे, मान सर्वर बोलते थे, मान छूट गया था. As far defect number 6 is concerned, it is with respect to the father not known in the judgment itself also. That's why I could not know this. Here it has been written. Judgment में is respondent number 9. There the formal part is not so necessary also. That's what judgment and degree are.
देखिए फर्स्ट अपील नंबर 251 of 2023. The learned counsel for the appealant has submitted that so far as defect number 1 is concerned, the same may be removed, the same may be ignored, and so far as defect number 4 and 6 are concerned, ऐसा करिए ना, इन स्टैम्प रिपोर्टर को बुला लीजिए, कुछ और फर्दर है तो आप जरा रुक जाइए, वो स्टैम्प रिपोर्टर आएंगे, उन्हीं के सामने ऑर्डर करिए, ठीक है, क्योंकि पता नहीं चल रहा है कि व्हाट इज इट दे आर ऑब्जेक्टिव. He will come here right now.
If it is possible, then
He will come here right now. You just wait for some time. ठीक है, समझ गए ना?
जी.
बुलाइए जरा स्टैम्प रिपोर्टर को, नाम देख के बुला लीजिए. और डिफेक्टिव केसेस में ना एक स्टैम्प रिपोर्टर को, जो भी रहे हैं यहाँ पर, उनको किसी भी एक को, जो फर्स्ट अपील के स्टैम्प रिपोर्टर है, उनको रहना जरूरी है. पता नहीं चलता है, लोग बोलते हैं स्टैंड स्टिल, फिर ये बोलते हैं रिमूव कर दिए, देयर इज अ मिसमैच.
Item 5, first appeal 320 of 2023.
12 बजे बुला लेंगे, 12 बजे आ जाइए,
Yes.
टाइम से आ जाएंगे, है ना? यस अपिला.
Lordship, I played for 3 weeks time to remove all the records. Defect number 1 is the limitation, Your Lordship. 10 days ahead. As per defect number 5, Your Lordship, the plaintiff number 2A is not alive, Your Lordship. That's why she has not been made.
So for that you will have to do the needful.
Yes, Your Lordship.
The
That's
2
why I
weeks
played
time.
for 3 weeks, Your Lordship.
What will you do with respect to 2A?
Substitution. I've already made their sons as the party, Your Lordship. I'll keep the statement and I'll try to bring the death certificate.
Who is your senior?
Anil Kumar.
He has not come to the court. ऐसे अपील में पार्टी नहीं बनती, राइट? अपील में ऐसे पार्टी नहीं बनता. You just call him.
He's
Because
not,
2 हफ्ता बाद भी वही चलेगा कहानी.
he's not present today, Your Lordship.
I'll post it tomorrow. He is required, okay? And you also be there. There cannot be a party position like this. Writ petition thodi.
Their sons are already.
Unless they are substituted, proper proceedings are taken out, proper orders are passed, you can't make anybody as party in the first appeal. ये डिफेक्ट आप नहीं रिमूव कर पाएंगे 3 साल में भी, ओके 3 वीक्स तो छोड़
There
दीजिए.
is a provision leadership in Rule 96.
हाँ, that is why
That has to be filed by.
we do not know what they will do. आप बता करके आइए. कल रखते हैं पोस्टमार्टम. Parties present post-mortem.
Item 6, first appeal 37 of 2024.
Appearance दे
Let's
दीजिए.
see, playing for 4 weeks time to removing other defects. Defects with court fee has already been removed.
So,
We need 4 weeks time to remove the rest of the defects.
what all are the defects? What all defects are there?
Like type copy of page number 15 and defect number 4. And there are some of the defects which has to be ignored.
So how you are paying for 4 weeks time to remove the defects? Then I will pass a peremptory order. Then how will that defect be ignored? Yes?
I will remove all the defects. Then just 4 weeks time.
In the land acquisition case, there were altogether 6 awardees. And you have 9 appellants here. How? How is it possible? Please. Proper steps for substitution is required to be taken. 15th of June 2023. He has expired after the judgment. One of the defendant has expired. One of the awardee has expired after the passing of the judgment.
Yes.
So you know under what provision you have to take steps. The defect is that you have to take steps. You can't just make them party like that. Yes, अभी वो बता रहे थे, समझाइए.
Rule 96A of
समझ में आ गया? सीनियर कौन है आपके?
Arvind Kumar Chaudhary. Arvind Kumar Chaudhary.
I am sure you must be aware of it.
Yes.
ठीक है? कितना टाइम चाहिए?
4 weeks.
The learned counsel for the applicant, you are for the respondent.
State.
The learned counsel for the parties are present. The learned counsel for the applicant prays for and is allowed time till 6th of February to remove the surviving defects and stroke or to file appropriate interlocutory application in connection with one or the other defect. Was this case on 10th of February for appropriate.
Item 7, first appeal 47 of 2024.
In these cases, I was paying for 3 weeks of removing the defect. And 2 defects leadership pertains to court fees and limitation, and relating to certified copy. For that also, leadership will file IA for removal.
All these cases are arising out of the same judgment.
No, leadership. Serials 7, 8, 9, and 10 are from common judgment leadership, and serial 11 to 19 are from leadership.
Are they arising out of the same land acquisition
Yes.
proceedings? So they are required to be clubbed.
Ladyship, they are required to be clubbed up, ladyship. However, the judgment
May be different.
two different batches of judgment have been passed, ladyship. And
There are other cases also arising out of these
there
land
are other
acquisition
cases.
proceedings. Do you have the list of other cases?
Ladyship, I have ladyship. So far as the first batch is concerned, ladyship, that is FA 47 till FA 54 of 2024, ladyship.
47 till 54.
54, ladyship.
It is arising out of land acquisition case number.
Arising out of land acquisition case number, it is not in the list today. Only four cases are in the
Our
list.
list का बताइए.
List में leadership serial 7, 8, 9 and 10.
7, 8, 9, 10. It is arising out of LA case number 6 of 2005-6.
Leadership.
Out of this LA case, there are other cases also which are out of list.
Leadership.
What all are the number of those cases?
Leadership, the other are 48, 49,
48, 49,
50 and 54 leadership.
50 and 54.
List
48,
These are not listed today, leadership.
just a moment. 48, 49, 50 and 54. These are first appeal numbers.
For first
First appeal numbers of, this is 24,
leadership, 24.
20. Very good.
And leadership,
These are out of list.
these are out of list, leadership.
What is the status of these cases?
48.
Leadership.
48 is there in the list.
49 leadership, I beg. 49.
तो चार में 49, 50 and 54.
52 also leadership. 52 is also
आप
not
कैसे
listed.
आप ऑर्डर लिखाएंगे आपको खुद ही नहीं पता है.
Leadership, I was 49, 50, 50.
Give us the first appeal which are arising out of LA case number 6 of 2005-6.
Leadership, all the cases that are listed today are arising out of till serial number 19, arising out of LA case number 6 of 2005-2006. However, there were two judgments that have been passed in these cases. One was passed in 27. One has been passed on 27th of 28th of July 2022. There are leadership. They are for serial FA 47 to FA 54 of 2024. Out of which FA 49, 50, 52 and 54.
I'm not able to comprehend whatever you are saying. I just want to know how many cases have been filed arising out of LA case number 6 of 2005-6. Are all these cases arising out of LA case number 6 of 2005-6? All these cases listed today? Apart from these cases, how many other cases have been filed arising out of LA case number 6 of 2005-6?
4 other cases.
4 other cases.
Leadership.
Give us the case number. FA number
49 leadership.
49,
52,
52,
54,
54.
that's
You have given only 3 case numbers.
49, 50 also listed. 50 is also not listed. 49, 50, 52 and 54.
FA case number 49, 50, 52 and 54 are the other cases which have been filed arising out of LA case number 6 of 2005-6.
Leadership.
Correct?
Leadership.
There are no other matters apart from this.
No leadership.
Others are relating to another LA case.
Leadership, the other serial number 11 to 19 are related to same LA case, but a different judgment has been passed on those cases.
But it is the same land acquisition proceedings.
Leadership.
The evidences were same or different?
Leadership,
No idea.
I won't be through with the presentation. What I would say, if I could suggest for leadership, let these two batch matters be dealt today. For today, be dealt in different in two cases leadership, and in the next day leadership, I will examine whether the evidences and everything are same leadership.
We will see that. जरा ये देखिए तो 49, 50, 52 and 54 का status क्या है? Same status, 52 and 54. लॉजिमा हो चुका है ना, 54 भी वही होगा. आपका 4 केसेस लॉजिमा में पोस्टेड है. लॉजिमा का कहानी खत्म हो गया. इसमें टाइम मिला है इफेक्टिव
Leadership, it will have to come to the
Bench.
leadership, because in, there is court fees deficit. If that is deposited in leadership, then it will not come. And there is a limitation also, 64 days.
So we can ask these matters to be posted. देखिए. ये पूरा बैच में लिखेंगे हर एक केस जो है ना. This is from serial number 7.
to 10.
You said that all these cases were
Leadership, the difference is leadership in serial number 11 and serial number 17. There are corrections that has to be made in the degree leadership. For that matter, both the cases will have to be sent to the lower court leadership. And 2 different judgments have been found. Only for that purposes I was putting leadership. That today both the batches may be in a different kind of leadership. And on the next day I will examine all the records and will submit it.
देखिए first appeal number 47 of 2024. Learned counsel for the appellant. How much time? 4 weeks.
Leadership.
Prays for and is granted time till 6th of February 25 to remove the surviving defects / to file appropriate interlocutory application. Preemptory. If the defects are removed, if this order is complied, owes this case on 11th of February in the supplementary cause list.
7 to 9.
It has been submitted by the learned counsel for the appellant that arising out of LA case number 6 of 2005-6, अच्छा इसको छोड़ दीजिए, इतना ही लिखिए, ठीक है. नेक्स्ट केस दिखाएं. नेक्स्ट
Item 8.
item 8. सेम ऑर्डर करना है.
Leadership.
ठीक है. आइटम 8 में सेम. नेक्स्ट आइटम 9.
Item 9.
Same order.
Leadership.
This is also arising out of 6.
Leadership.
Next.
Item 10.
Same order. ये इन चारों का कॉमन ऑर्डर ड्रॉ करेंगे, ठीक है. सिंगल ऑर्डर में इसको कीजिए. हाँ, उसके बाद इसमें लिख लीजिए ये चारों केस. It has been submitted by the learned counsel for the that these matters may be tagged to be heard.
Item 11.
Just a minute. Considering the aforesaid submission, these matters are tagged and will be heard together. 11 बताइए.
Leadership in 11, there is a defect number 11. That is mismatch in the award judgment and the decree leadership. For that, it has to be sent to
Defect number 11.
leadership.
FA number 55 of 2024, the learned counsel for the appellant refers to defect number 11 and submits that the certified copy of the judgment be sent back, judgment and award / decree be sent back to the court concerned for correction. Office is directed to send back the certified copy of the judgment and certified copy of the award to the concerned court for necessary correction. Post this case on, अभी हम लोगों ने कौन सा डेट दिया है चार्ज का?
Leadership 11th February has been postponed.
11. Post this case on 11th of February in the supplementary process. Next one.
Leadership in serial 17 also it has to.
Same order?
Leadership, yeah, there is a correction leadership regarding parentage. That has to be also sent.
Just a moment. In the meantime, it will be open to the appellant to remove the other defects.
Okay, leadership.
ये हो गया सर. Next एक के बाद एक. Next case बताइए.
Item 12, First April 56 of 2024.
Leadership in this simple order for removal of defects. Leadership.
It is arising out of 6 only.
Leadership is also arising from 6.
एक सेकंड. ये जो ऊपर के 4 ऑर्डर किए हैं ना, उसके साथ ये भी रहे और उसमें भी नेक्स्ट डेट कोई 11 तारीख का. अभी रहने दीजिए एक सेकंड. नेक्स्ट बताइए.
Item 30, First April 57 of 2024.
सेम ऑर्डर इस बैच के साथ.
Leadership.
ठीक है. इस बैच के साथ सेम ऑर्डर.
This is different judgment. Leadership, same case, LA case, different judgment. Leadership. From serial FF.
Just a moment. Let me just have a look at it.
Ultimately, leadership.
These matters will be tagged.
Heard together. Leadership.
This is arising out of award number 79. And these were arising out of award number
There are different awards. 111.
award number 81. Different reference case, right? The earlier batch is LAR case number 441 of 2021, 2012.
439. Leadership.
This is 442 of 2012.
The present one. Leadership.
हाँ present.
Yes. Leadership. The present.
पुराना वाला 441 था.
Leadership, there is no order in which it has been clubbed. Because earlier cases starts with
For different LR cases.
leadership. There is no chronological order in which it has
Okay,
been set.
no problem. इसमें same order करना
Leadership.
है. Same order होगा. और batch वाला. Next बताइए.
Item 40,
Same order.
Same order. Batch का same order. Next.
Item 15,
Same order.
Same order. Item 15. Next.
Item 16,
Same order. इसमें भी same order. ये पूरा batch है, ठीक है? Considering the fact that all these cases are arising out of land acquisition case number 6 of 2005-6, these matters are tagged to be heard together.
Leadership, if same order could be passed in serial number 18 and 19 also.
18 and 19
Leadership.
same order 18 19 एक ऑर्डर में सिर्फ जाएगा, उसको अभी टैग नहीं कर.
Leadership and
the next 17,
serial
हाँ
17.
17. Okay, 17 we are sending it back.
Leadership.
this is 17.
वो जो सेंड बैक वाला ऑर्डर हुआ था इसमें, ठीक है? इन द मीन टाइम वी शैल रिमूव द सर्वाइविंग डिफेक्ट्स इसमें भी date, next date will be on 11th of February.
Right.
Okay?
Supplementary.
18 बताइए supplementary. Next बताइए.
18.
19, 18 also.
Same.
It has to go to the court.
No, it should be just
Tag करना है.
Tag.
वो जो batch के साथ है ना, this 18, serial number 18.
18.
It will go with the batch, है ना? और tag होगा ये इसके साथ.
19.
19.
Same. It has to be tagged with the
Batch?
4 weeks to.
इसको भी batch के साथ डालना है. So there are 2 cases where the records are to be sent back. Serial number
11.
Serial number 11.
11 and 17, in which we are passing a separate order. We are asking you to remove the surviving defects in the meantime. But the next date of all the cases is on 11.
Highly okay.
बाकी सब cases में preemptory order है. Either to file interlocutory application or to remove the subject. In case if you feel that any of the defect is to be ignored, you can file your interlocutory application. DFT नहीं करना चाहते. ठीक है, ऐसा order नहीं करेंगे. Will not do that.
बाकी सब preemptive order में
सब में
और
preemptory
batch,
order है.
tag order.
हाँ, batch type का है. ठीक है.
Item 20, first appeal 136 of 2024.
ये सब क्या है?
In this case, Lordship, 2 defects are there, Lordship. But defect number 1, Lordship, that will be removed in course of day, Lordship. But defect number 2, Lordship, that is the plaintiff number 4, Lordship, which appears as certified copy of degree. The name is not there in the memo, Lordship. For that, Lordship, I'll file an application since he had died prior to filing of this application. And therefore, Lordship,
After the decree.
Lordship,
After the decree.
prior to the filing of this first appeal, Lordship.
But after the decree. When did he die?
That entire details, Lordship, is yet to come, Lordship. File the entire thing we have to, in any case, Lordship, I have to file the give the details, entire details,
That's
along with the
Suppose a person dies during the pendency of the first, during the pendency of the
yes,
trial.
Lordship. Before the preparation of the degree and the judgment.
Before the judgment only
Yes,
he
yes.
dies, then what is the remedy?
Lordship, the remedy is that there is one judgment of the Honorable Supreme Court that I'll place in this case also. Perhaps, Lordship, in this case also he has died prior to the judgment. In this case, perhaps, since I
Could be, you do not.
we are Lordship filing we are relying upon judgment of the Honorable Supreme Court of Justice R. Bhanumati, wherein Lordship the similar case was there and he was not substituted in first appeal. Neither he could not be substituted in the second appeal. Although in the second appeal an application was filed under Order 1 Rule 10, but that application was not considered by the Honorable High Court and the matter went to the Honorable Supreme Court.
And that remained pending.
That was dismissed on that ground that since the petitioner was not substituted also in the first appeal, and then how could have been he could have been substituted in second appeal. That was also a very complicated case. That matter went to the Honorable Supreme Court. In that case, Lordship Justice Bhanumati has given the finding that since these are the technicalities of the thing, and for that the parties should not suffer, and that application was treated to be a substitution application, and the matter was remanded back to the first appeal court in the High Court, Honorable High Court. And after substituting the same in the Honorable Supreme Court, that judgment I'll be placing Lordship in this case also.
Was it under 142?
It was not under 142. The
Otherwise
Order 1
also
Rule 10 and Order
the first
22.
appeal is a continuation.
Yes, Lordship. This is also my second argument.
Once the second,
Since,
once the
yes.
second appeal is admitted, it also becomes
That has also been
continuation of
observed in that judgment, since it was there in the first appeal, and first appeal is a continuation of suit. The court can ignore those things, and after only the technicalities of things, the party should not suffer. It is always
provided the
Yes.
appropriate application regarding abatement, etc. is
yes,
also
yes.
setting
Everything is
aside
required to be
abatement
filed.
or whatever.
110 will be filed, Lordship, because now the party is required to be added. And abatement, Lordship, I don't think abatement. The Honorable Court, Supreme Court had said the Order 22 Rule 4 application should have been filed. That too also, Lordship, I am not very much satisfied since Order 110 is for adding of the parties. 22, 2, 3 and 4 is for substitution. The thing is that now the substitution is not here.
No, but the first appeal being a continuation of suit. in under such, you've examined it.
Yes, Lordship.
Do
All
the-
the provisions will be given, Lordship, in the petition. Read with such and such and such, that Lordship will, even with
How much
151
time
will
do you
also be
need?
there.
How much time?
3 weeks, Lordship.
देखिए, FA number 136 of 2024. The learned counsel for the appellant prays for and is allowed time till 27th of January 25, either to remove the surviving defects or to file appropriate application
Application policy.
in connection with one or the other defect.
The court fees have already been filed, Lordship. 50,000 court fees we have filed.
Post on 29th of January. कोई भी चीज बिना नोटिस किए तो नहीं करेंगे, even if there is an interlocutory application.
Yes, Lordship. Lordship will file. Even that application, the notice will go.
No, I have filed one caveat notice.
Oh, they are up here.
You are for the life.
I am for the respondent.
Has any of the respondents concerned defend you? You are for the defendants.
Yes, ma'am.
Now the respondents.
Now the respondents. Have any of the defendants expired?
I will receive further instruction. I have filed on 9th of September 2024. Later on, thereafter I have no instruction.
Might not have, because Lordship, at the time of filing, I had inquired the matter. As petitioner, appellant number 4 was, the plaintiff number 4 was not there. He had died, Lordship, therefore his name is not there. Shankar Mahto.
शंकर महतो उनकी तरफ से नहीं statement
हाँ,
filed.
therefore we have to file an application for that.
आपने कुछ ही लोगों की तरफ से केबिन फाइल.
हाँ, हमने किया है मतलब कुंज बिहारी मानकी, मनोज कुमार, शिव नारायण, 3, 4, 5, 6, 7 सभी की तरफ से.
All Lordship, only the respondent number 1 Lordship is the
1 and 2
state Lordship.
स्टेट को छोड़कर
1 and 2 is the state Lordship. For that, I'll have to serve a copy Lordship. We have not done that.
3 to 7 तरफ से है.
Plaintiff number 4 of CC. You are for the appellants?
Lordship. Plaintiff appellant.
Appellants.
Plaintiff.
Plaintiff भी अपना substitution नहीं करेगा.
नहीं, वो
क्या
सब तो हम क्या कहें उसमें?
इससे क्या ही हार्म होने वाला है? अगर plaintiff का substitution नहीं हुआ amongst all the other plaintiffs.
उसका जो right to decide होगा, then the heirs of the Shankar Mahto will not derive any benefit.
22(9) में जो अबेट कर जाता है.
नहीं, it may also abate for only one person who has the heirs of the person who
Only
has.
to that extent.
That will be their Lordship. But since Lordship, these things are their Lordship, we can.
ठीक है?
Item 21, first appeal 149 of 2024.
Yes.
I know there is a single because we are short of vote fee by 27 people. And that will be removed. Within
Defect number 2 and 3. Defect number 2 and 3.
rest of the defects are removed.
Original power of attorney have you filed?
Yes,
Where is it? When did you file? When did you file the original power of attorney?
on 15.
Before whom did you file?
Nothing registration.
Where is nothing has been mentioned. Where did you file? Mr. Sani को बुला के लेके आए. Mr. Sani को बुला के लेके आए. जो चीज़ आपको नहीं पता है उसके बारे में क्या ही बोलूं. हाँ तो बोलो.
Item 22, first appeal 154 of 2024.
Yes.
I'm praying for 2 weeks time for removal defect regarding port fee. Only one defect is remaining.
want to enter appearance?
IS by IE number 7.
IE number 7479 of 2024. The interrogatory application has been filed seeking leave of this court to file वकालतनामा on behalf of respondent number 1 to 4. कोई objection है आपको?
नहीं
Counsel for the appellant has no serious objection to the plea. Accordingly, IA is allowed. The appeal is still defective only with regard to furnishing of court fees. Time till 27 January is granted to the appellant to remove the surviving defects. Preemptory. Pose this case under appropriate heading on 29th in supplementary process. You just admit and call for the LCR.
Yes.
If they remove the defects.
Yes,
Because that is a preemptory order.
That's
I've
okay.
allowed you IE.
yes, ma'am. Because I cannot appear so moto unless the.
No.
Order Saturn 23, second appeal 360 of 2016.
Respondent number 1 has died during pendency of this application. I have filed IE for substitution.
Where is the IE?
IE number 13885
When did the respondent number 1 die?
in the year 2020. I would say. Exact date is not known to the applicant.
Who are the legal heirs?
Her son, Your Lordship.
This second appeal is admitted.
No, Your Lordship.
This second appeal has not been admitted since 2016. एक आध जनरेशन और बदल जाने देते. देखिए ऐसे नंबर 360 of 2016 with IA number 13885 of 2020. Learned counsel for the appellant has submitted that the petition has been filed. इसमें आप setting aside abatement भी नहीं फाइल की.
Here, Your Lordship.
इसी में साथ में ही है.
Condolence appeal.
The interrogatory application has been filed for substitution of deceased respondent number 1 who has expired during the pendency of this case. Her son is sought to be substituted, whose detail has been mentioned in paragraph 4 of the interrogatory application. Issue notice to the proposed legal heir and successor of the respondent number 1 in IA number 13885 of 2016
24 years.
or of 24. The notice should accompany a copy of the memo of appeal. पता ही कैसे चलेगा उनको क्या केस. मेमो ऑफ अपील साथ में लगा देंगे. अंडर रजिस्टर्ड कवर कहाँ के हैं पार्टी?
Department is there.
Under registered cover with 80 and also ordinary process. The requisites be filed by 13th of January. Post this case on 3rd of March, awaiting service.
Item 24, second appeal 307 of 2018.
Yes.
In this case, when I has been applied for substitution of sole respondent.
When did the sole respondent die?
Sole respondent died 19/7/2024.
Who are the legal heirs? Were you appearing for the sole respondent?
Yes, Your Lordship.
Will
I
you
have-
seek instructions?
Yes, Your Lordship. I have anyway filed the information petition, Your Lordship.
Okay. With wakalatnama?
No, Your Lordship, for Wakalatnama.
So you seek instruction and file
Yes,
wakalatnama?
Your Lordship.
This IA can be allowed?
Yes, Your Lordship. There is no limitation application, Your Lordship.
There is no limitation actually there. It was filed within time.
इसके साथ में ही फाइल किया हुआ सिटिंग एसेट अमेंडमेंट का ही प्रेयर है दोनों साथ में.
दोनों साथ में ये क्या करना है? IA number 13850 of 2024 in SA number 307 of 2018. The ये वाला नहीं है, कोई और है.
13753.
13753. With IA number 13753 of 2024. You have filed 13753?
यस इसमें दो आईए हैं जो एक ही डेट पे आगे पीछे पता नहीं चल रहा है कौन सा. मेरा आईए में सेटिंग असाइड अमेंडमेंट ऑर्डर 22 रूल 4 and 9 मेरा वाला.
Order 22 Rule 10A में आपने फाइल की.
ये भी
मैंने फाइल की, Your Lordship.
इसमें तो वकालतनामा है सबका. Along with that.
And the index was not.
Yes, Saif Ahmed Khan.
There must be five legal names.
5 legal years, yes. You have filed wakalatnama on them for their behalf. का नाम टैली नहीं कर रहा.
स्पेलिंग में थोड़ा सा जैसे उन्होंने स्पेलिंग में थोड़ा सा
नाम भी नहीं टैली.
फर्स्ट वाला है मोहम्मद सफी अहमद खान वो मेरे में भी है. फिर जमशद खान वो मेरे में भी है.
नहीं, आप लोग को रिकॉर्ड दिखाना तो देखना हम तो नहीं सिखा सकते. दिखाइए. जस्ट हैव अ लुक एट दिस. यही नाम से सब्स्टिट्यूशन करें. इन्होंने वकालतनामा ऐसे फाइल किया. दिखाइए. जस्ट शो इट. नाम अधूरा भी है. जस्ट टैली दिस. शमीम का उसमें बेगम भी लिखा हुआ है कि कुछ लिखा हुआ है. there is a you just have a look at it. इसी नाम से सब्स्टिट्यूशन कर देते हैं जो इन्होंने वकालतनामा के साथ अटैच किया. दैट वुड बी बेटर ना. अदरवाइज आइडेंटिटी का प्रॉब्लम होगा. जस्ट हैव अ लुक एट इट. इट्स नॉट द सेम.
ठीक पर लोग जो आई है उसी
उसी के अनुसार कर सकते हैं. You will carry your corrections in your interlocutory application accordingly.
Yes, I can do that. I can carry out necessary correction in the memo.
That's right, but in your interlocutory application
Yes.
also. The learned counsel for the respondent has submitted that IA number 13850 of 24 has been filed under Order 2210A of CPC, intimating this court about the death of sole respondent who died on 19/7/2024. Along with the said interlocutory application, the wakalatnama of the legal heirs and successors of the sole respondent has already been filed, which also contains the details of their parentage and address etc. along with the वकालतनामा, which are as follows. ये वकालतनामा के साथ attached है, इसको लगा देंगे, ठीक है? The learned counsel for the appellant has submitted that IA number 13753 of 2024 has been filed seeking substitution of the sole respondent, giving the details of the legal heirs and successors in paragraph 3 thereof. However, there is slight mismatch in connection with the description. He undertakes to carry out the necessary corrections. He prays for and is allowed to carry out the necessary corrections in IA number 13753 of 2024 with respect to the details of the legal heirs so that it matches with the information which has been furnished by the respondent through the IA number 13850, attaching the list of the legal heirs and successors along with the wakalatnama. The necessary corrections be undertaken in writing during the course of the day. Considering the submissions made by the learned counsel for the respondent has no serious objection so far as the substitution of the sole respondent is concerned. Accordingly, IA number 13753 of 2024 is hereby allowed, and the in terms of the prayer made therein, that should be sufficient. In terms of the prayer made therein, the counsel for the appellant is directed to carry out the necessary corrections and the necessary insertions in the memo in red ink during the course of the day. Both the IAs are accordingly disposed of. This is an admitted appeal.
Yes.
Where is the substantial question of your claim? This appeal has been records received in. Records आ गया है? नहीं आया है, क्यों?
Substantial question of law, as far as I remember, with regard to gift.
Yes, it has been framed by the order dated 10/11/22, but the records have not yet been called. This court finds that the case has been admitted by order dated 10/11/2022 after framing the substantial question of law for consideration in the second appeal. However, the records have not been called from the concerned court. Office is directed to call for the connected records from both the courts. Let this order be communicated to the concerned court through fax. Pose this case on March 4th under appropriate heading.
Item 25, first appeal 86 of 2023.
Yes?
I have for condemnation of delay matter. And delay after 1,622 matter I signed the exam in para 2 and 3 matter. Earlier matter of the FA for same cause of action 5, which was got dismissed for dismissed for default on 17/5/2019. Thereafter matter due to COVID pandemic situation, the petitioners could not approach and they approached in the year 2022 matter and without obtaining the certified copy matter. Immediately after getting the documents, I have filed the instant
Why did you file your restoration application?
अब 2019 का पहले दूसरा कोई फाइल कर दिया
तो आप फ्रेश फर्स्ट अपील फाइल कर देंगे
19 में ही डिसमिस हो गया।
तो समझाइए ना। आपका कोई एक एडवोकेट फाइल कर देगा फर्स्ट अपील, डिसमिस फॉर डिफॉल्ट हो जाएगा, फिर दूसरा एडवोकेट आके दूसरा फर्स्ट अपील फाइल कर देगा। यस, नॉट परमिसिबल। यस मिस्टर रॉय, is it permissible? One counsel files a first appeal, it's to dismiss for default. Then another counsel will come and file another first appeal.
Proper recourse would have been filing a CMP for restoration.
Yes, you can't do this. Proper recourse kya? How is it possible? Dismiss for default.
The first appeal was not adjudicated on merits.
Maybe, but still, we can't. How do we permit this kind of an approach? And then he's talking about condonation of delay. Dismiss for default is also a judgment, isn't it?
No, it is not. In my respectful submission, it is not a judgment.
I don't
On
know.
merits.
But the proper course is to file an application for restoration. There is no end to it. Then I am not satisfied.
And liberty में भी
कोई लिबर्टी हम क्या ही देंगे आपको? कुछ लिबर्टी नहीं देंगे. This we will not permit.
but not on merit.
So you can file it any time through another counsel. ये किस तरह का डिसिप्लिन? पुराने एडवोकेट को वकालतनामा दिए थे ना, सर्टिफाइड तो कॉपी दिए होंगे, फाइल किए होंगे.
इसके बारे में जानकारी नहीं है।
आप हमको satisfy करिए how this second appeal is, this first appeal is maintainable. It is your duty to satisfy this court. We are not concerned. You satisfy how this first appeal is maintainable. मर्ज किया नहीं किया, क्या हुआ मेरा? पढ़ लिख के आइए, जजमेंट लेके आइए, तभी मानेंगे, नहीं तो नहीं मानेंगे. सूट में तो डीएफडी हो जाने से सेकंड सूट फाइल हो जाता, उसमें भी बहुत कंट्रोवर्सी. ठीक है, इतना सिंपल नहीं है. यस मिस्टर रॉय, इट इज नॉट सो सिंपल. सूट
It is
फाइल
all simple, हाँ. Same cause of action के लिए there are circumstances that for the same cause of action we can file a fresh suit.
फ्रेश सूट फ्रेश अपील इस तरह से कैसे ही हो You see the right has crystallized in favor of one or the other person ना आप हमको satisfy करिए I am not satisfied
2 weeks time.
थोड़ा समझिए अच्छे से किसी सीनियर से बात करिए समझिए थोड़ा रिसर्च करिए तब सुनिए FA number 86 of 2023 Counsel for the appellant is present He submits that IA number 11895 of 2024 has been filed seeking condonation of delay. He also submits that earlier one first appeal number 13 of 2018 was filed which stood dismissed for default / non-prosecution on 17/5/2019 by this court. Instead of filing any petition for restoration of the first appeal, a fresh first appeal has been filed, which is FA number 86 of 2023. Counsel for the appellant is directed to advance arguments as to how the present first appeal is maintainable once the first appeal number 13 of 2018 has been dismissed for non-prosecution. ये non-removal of defect की नहीं dismiss हुआ, for non-prosecution हुआ, है ना? वकील साहब appear नहीं हुआ होंगे, correct? अगला हफ्ता रखें, कब रखें बताइए?
2 weeks.
Counsel for the appellant submits that prays that the matter be posted on 28th of January. Post on 28th in supplementary cause list. He shall file the judgments which he seek to rely upon by 24th of January. अपना notes मोड सब file करिए, हम ऐसे नहीं करेंगे.
Item 26 first appeal 298 of 2023.
उसका जो record है ना first appeal का साथ में place कर दीजिए. Office is directed to place the records of first appeal number जो 18 वाला case है ना along with the records. Yes.
This is an IML
आइए boss.
for termination of delay of 207 days
Okay.
for filing the first appeal.
You are for the respondent.
State.
State. Who is for the respondent?
This is only litigation equipment.
The state is the only
State is
respondent.
fine, so respondent.
Any objection for condonation of delay? Sorry?
At present, your lawsuits from my side because I have not seen the instruction from the department as to whether
I do not know. If you want to say that you have no objection, we will condone the delay. If you have objection, you file a counter affidavit. Objection के लिए counter file first appeal है ना, बिना counter के हम आपका ये सब verbal objection नहीं सुनने वाले. ज़्यादा delay है भी नहीं, unnecessary क्यों ही आप इसको परेशान कर?
कोर्ट फीस भी जमा कर.
कोर्ट फीस भी जमा कर, ठीक है? कोई बात नहीं, लिखिए. IA number 11876 of 2024. Learned counsel for the parties are present. Counsel for the appellant submits that petition for condonation of delay has been filed to the extent of 207 days. He submits that the matter arises out of land acquisition proceedings. The land has been acquired for the state. Correct?
Yes.
The appellant, as per the interlocutory application, the appellant is a poor person and is a resident of a remote area, and some time was taken for him to make arrangements for filing the first appeal. No counter affidavit as such has been filed to the interlocutory application. and no serious objection has been raised by the learned counsel for the respondent in connection with condonation of delay. He has submitted that the required court fees has already been filed. That should be sufficient. Being satisfied with the cause shown, RA number 11876 of 2024 seeking condonation of delay is hereby allowed. अब बताइए क्या बोलना है? कौन सा अवार्ड से ये आ रहा है?
इसमें लोअर कोर्ट में करेक्शन के लिए क्या होता है, वो आया कि नहीं वो देख लेते हैं।
सब आ ही गया है, अब और कोई डिफेक्ट नहीं।
उसको एक बार वेरीफाई कर लीजिए।
क्या ही वेरीफाई करना है इसमें? इसमें कोई और डिफेक्ट पॉइंट आउट
नहीं और कुछ नहीं। उसमें से कहा गया था कि एक बार आ जाने के बाद आप वेरीफाई कर लीजिए, उसमें डिफेक्ट लगाओ।
Admit call for the records from the concerned court. कितने क्लेमेंट हैं इस अवार्ड में?
एक ही है इसमें से एक ही।
You have come for enhancement of compensation.
Yes.
The appellant has approached this court seeking enhancement of compensation. Posed this case on March 25 for final disposal in the supplementary process. तैयार हो जाइए enhancement के लिए।
अपीयरेंस दे दिए।
Item 27, Partition 88 of 2024.
Yes.
Let us say one IA has been filed for the condemning the delay of 19 days.
90.
No, 199.
19. This is again from land acquisition.
Yes.
Part of the award.
What is under challenge?
Award number 4.
You are seeking enhancement.
For award number 14.
Award number 4.
एक बार वो वाला रिकॉर्ड दिखाना जो अभी एक बार लैंड एक्विजिशन केस नंबर इसका जो लैंड एक्विजिशन केस नंबर है ना, ये LA केस नंबर 5 ऑफ 2019-20 है। स्पेशल लैंड एक्विजिशन ऑफिसर, ये है केस है पलामू डाकुमेंट। इस पर्टिकुलर केस नंबर से जैसे देखना पड़ेगा कि कितने और केसेस हैं कि नहीं। चेक करना जरूरी है। हाँ बताइए। What is your grievance? क्या ग्रीवेंस है आपको? आप लिमिटेशन तो है, लिमिटेशन तो कंडोम कर देंगे। आपका केस में क्या ग्रीवेंस है?
challenging the award.
Award, will you have come for enhancement? Or some claim has been rejected?
The two award has been found, award number 7 and award number 14. Award number 7 is for the land and award number 14 is for the building. But for that land, the enhanced compensation has been granted by the.
He has no grievance. He has no grievance for land.
He has no grievance for the land. Award number 7. With regard to award number 14, with regard to the structure of the building, he has said that there are double-story building was there. But he has not produced any map over.
So he is only concerned with the valuation of the building.
Yes, madam. And the award was given on the basis of the roof structure. The award has been paid. So he has said that for the second story building he has not paid that. Only that much.
Okay. Only that much of
Only
grievance.
that much.
So far as the valuation of land etc. is concerned, you have only grievance
with regard to the
structure.
Structure. That is only challenge.
FA number 88 of 2024 with IA number 12436 of 2024. The learned counsel for the appellant has submitted that a petition for condonation of delay of 19 days has been filed through the interlocutory application. He has referred to the abatements made in the interlocutory application to submit that the delay is on account of certain complication. The learned counsel, no counter affidavit as such has been filed to the interlocutory application. The learned counsel for the state has no serious objection for condonation of delay of only 19 days in the first appeal. Considering the abatements made in the interlocutory application and being satisfied with the cause shown, the delay in filing the first appeal is hereby allowed. IA number 12436 of 2024 is hereby condoned. IA number 12436 of 2024 is hereby allowed. फिर first appeal में लिखिए. The learned counsel for the appellant has submitted that the land along with the superstructure standing on the land was acquired and the appellant has grievance in connection with the valuation of the superstructure. So far as the land is concerned, the appellant has no grievance. Correct?
Yes.
First appeal को admit कर लीजिए. Admit, call for the records from the concerned कोर्ट. अभी एक तो केस फाइनल डिस्पोजल में कौन सी तारीख को रखा? कौन सी तारीख को रखा? 11th March. Pose this case under the heading for final disposal on 11th of March in the Supreme Court.
11th or any other date.
क्यों?
That I will be in Rajasthan at that point. Any next week will come, only on that.
27 मार्च फरवरी को रखना है. 27 फरवरी 27. छोटा सा मैटर है.
छोटा सा ही मैटर है. ओनली एक ही अवार्ड के लिए है बस, जो सुपर स्ट्रक्चर जो है उसका वैल्यूएशन नहीं दिया हुआ.
Let this order be communicated through fax to the concerned court.
Pastoral case item 4, first appeal 251 of 2023.
हाँ, आपको पता चला?
जी.
इतना लोग आने का काम नहीं है. देखिए ये जो है स्टैफ रिपोर्टिंग में आप लोग लिखते हैं ना कि स्टिल नॉट रिमूव और ये कुछ रिमूव कर देते तो हम लोग को पता नहीं चलता है कि मतलब व्हाट इज इट दैट यू आर ऑब्जेक्टिंग टू. अब समझ में आ गया? कुछ इनका बाकी है रिमूव करने के लिए? नहीं है ना. थोड़ा सा ध्यान रखेंगे क्या चीज़ नहीं है पता नहीं चलता आपको कोर्ट में, तो क्या ही इनको हम बोलें.
1, 4 and 6.
1, 4 and 6. 1, 4 इग्नोर करना है. 4 and 6 you have removed.
One.
First appeal number 251 of 2023. Counsel for the appellant is present. The learned counsel for the appellant submits that defect number 1 with regard to typed copy of page number 9 be ignored. He submits that the same is fairly legible. यही बोलना चाहते हैं ना? And it is the
First title of the three.
just the cause title of the judgment. The party position etc. is apparent from the main judgment. Considering the submissions, the defect number 1 is ignored for the present. So far as the other defects are concerned, he submits that the same has already been removed. The concerned stamp reporter has also confirmed by coming to the court that there is no surviving defect in connection with defect number 4 and 6. अब तो कोई defect नहीं
No, there is only a limitation is there.
is to be filed.
No, it has been filed.
Notice
10 days
का
that
किसका है? State है? Respondent?
नहीं, private parties.
Private. देखिए
Arising up out of the same case, my lords, another FA is pending.
बताइए FA number.
That is, FA number is 264 of 2023.
वो क्या defective?
नहीं.
Or they have filed it.
Other respondent has filed.
The learned counsel submits that arising out of the same judgment, another first appeal being FA number 264 of 164 of 2023 has been filed before this court by the respondents of the present case. Correct?
Yes, ma'am.
Post this case day after tomorrow along with FA number 164 of 2023. उसमें जो नोटिस एक्सेप्ट कर लेंगे हम लोग देखते हैं, है ना? एक बार रखते हैं, विथ कर देंगे. This appeal will be heard along with FA number 164 of 2023. और defective तो नहीं?
नहीं और नहीं.
नहीं वो 164 defective.
नहीं, this notice has been served upon me. That's why I mentioned.
ठीक, उसी दिन रखते हैं. ठीक.
Console case item 21, first appeal 149 of 2024.
Yes.
There are 3 defects in your lordship. First, defect number 2, that original purpose for ordinance.
Yes, very good.
I pray for 3 weeks time, your lordship.
How the concerned counsel, where is she? Under whose instruction did she submit that all these defects have been removed? बताइए. आप लोग जूनियर को इंस्ट्रक्शन भी सही से नहीं देते.
No instruction I will procure the original purpose for ordinance.
आप समझे नहीं. आप जो अपीयर हुई थी उनको बुलाई, कहाँ है वो? She said that this defect has been removed. She was not able to give the date on which this defect has been removed. कितना टाइम चाहिए आपको?
3 weeks time.
FA number 149 of 2024. Learned counsel for the appellant prays for and is granted time till 27th of January 2025 to remove the surviving defects preemptively. If the defects are removed within time, post this case on 29th of January under appropriate heading. The supplementary list. Preemptory order है. 3 हफ्ता हो गया ना पूरा? 3 हफ्ता मांगे थे? 3 हफ्ता हो गया?
Appearance.
Memo of appearance देंगे. Appearance देंगे.
Item 28, first appeal 99 of 2024.
Yes.
Did of 688 days.
It is appeal arising out of
Partition suit loss and due to inadvertence in bona fide mistake, first appeal was filed before the learned district judge lordship, which was permitted to be withdrawn. Thereafter, this appeal has been filed before this one.
will issue the notice.
Yes.
देखिए, IA number 10977 of 24 in FA number 99 of 2024. Issue notice in the interlocutory application as well as in the first appeal. The learned counsel for the appellant submits that initially the first appeal was filed before the district judge and thereafter the appeal was permitted to be withdrawn and the present first appeal has been filed, which has caused delay, which has been explained in the interlocutory application. Pose this case on अंडर कौन है रेस्पोंडेंट कहाँ का है
सब जमशेदपुर
का
धनबाद के हैं और जमशेदपुर
respondent how many respondents are
there are only two respondents total.
1 and 2 under speed post and also under ordinary process for which requisites be filed by 13th of January 25. Let the records be called for from the concerned court. अभी एडमिट नहीं कर रहे हैं क्योंकि डिले कन्वर्ट नहीं हुआ, records call for कर रहे हैं. एडमिट डिले तो हो ही जाएगा कन्वर्ट. Let the records be called for from the concerned court. Pose this case on 27th of February. Awaiting service report and the records. Office to track speed post delivery and prepare appropriate office note with regard to service reports.
Item 29, first appeal 132 of 2024.
This case I have to find Wakalatnama on behalf of the respondent insurance company.
Respondent number?
112.
This is first appeal.
This is first appeal.
Arising out of what proceedings?
Money supervisors. No, the insurance claim was there of a jewelry shop which has been
allowed.
No,
rejected.
Which has been
declined.
Which has been not wrong. But the respondent number 4 has no role as per the include order itself, my lord. Include judgment, my lord. The respondent number 4 state of Jharkhand has no role in this matter, my lord. And no clear leave was short from the respondent number 4.
Maybe, but you were late party. So you be there. Be happy that you don't have to do anything.
Make your fees.
देखिए, इसमें condonation of delay भी है क्या?
Yes, yes. Let it come after 2 weeks after filing Wakalatnama. Because it's a company matter of it, so.
FA number 132 of 2024 with IA number 13126 of 2024. Counsel for the appellant is present. Mr. Alok Lal accepts notice on behalf of the respondent number 1, 2 and 3. The learned counsel for the state representing respondent number 4 is present. Mr. Alok Lal prays for 2 weeks time, prays for and is granted 2 weeks to file Wakalatnama on behalf of respondent number 1, 2, 3. Pose this case on 27th of February in the supplementary cause list.
27th of
February in the supplementary cause list. In the meantime, Mr. Alok Lal shall file Wakalatnama. नहीं वो तो हो गया उसके बाद क्या in the meantime the records be called for from the concerned. Let this order be communicated. कितना दिन का delay है?
36 days.
36 days.
delay का बहुत कुछ नहीं, but because
नहीं आ जाएगा ना रिकॉर्ड
record मतलब because it is a company matter, so I
कोई
would
बात नहीं, आपको जो करना है करिए. In the meantime, it will be open to the respondent to file their reply to the petition for condonation of delay, if so advised. आप लेकिन तैयार हो जाइएगा, रिकॉर्ड आ जाएगा.
Item 30, first appeal 240 of 2024.
The delay for 55 days.
Yes.
Yes,
Any objection?
I'm the plaintiff respondent, Your Lordship. And
Any objection
I
for
have-
condonation of delay?
Yes, my lord, I have to file first wakalatnama, and they.
You have not yet filed
Appellant will be
wakalatnama?
directed. No, I have not filed. I have to file.
You wakalatnama for respondent number?
Respondent number 1, Your Lordship,
Okay.
and 2 is the
First appeal number 240 of 2024 with IA number 11418 of 2024. Interlocutory application has been filed seeking condonation of delay of
For 55 days.
455 days. Mr. Anil Kumar Sinha accepts notice, advocate accepts notice on behalf of respondent number 1 and submits that he shall file wakalatnama and also reply to the interlocutory application for condonation of delay. The matter arises out of partition suit. This case on fifth of March 25. In the meantime, the wakalatnama on behalf of the respondent be filed. On behalf of the aforesaid respondent be filed. The reply to the interlocutory application be also filed along with the wakalat. That the records be called for from the
Appellant
concerned.
will be directed on
Yes,
some.
definitely. I will serve the copy of the memo as well as IA petition also.
The counsel for the appellant undertakes to serve the copy of the memo of appeal along with its enclosures and also interlocutory application to Mr. Anil Kumar Sinha, advocate, by tomorrow. रसीद फाइल कर देंगे नहीं तो टिकट रह जाएगा.
For admission, item 31, first appeal 103 of 2024.
Yes, appellant.
But partitions should have been dismissed. What is for admission notes?
देखिए FA number 103 of 2024. Admit. Call for the records from the concerned court. Let this post this case on notice करना होगा.
Notice करना.
Issue notice to the respondents under speed post as well as ordinary process, for which requisites be filed by Monday. Office to track speed post delivery. Post this case on (24th of February), awaiting service report. In the meantime, the records be called from the concerned court.
Item 32, first appeal 239 of 2024.
Yes.
It's coming up for the first time. The original Bobet suit filed by the appellant was dismissed.
First appeal number 239 of 2024. Admit, call for the records from the concerned court. Let notice be issued to the respondent number
1 to 20.
1 to 28.
27. 28.
1 to 27.
27.
28 को कौन represent करते हैं?
That is general public of the locality, but we just paste it. That is a formality which is to be, but now
Respondent number 1 to 27.
G.
For which requisite under speed post speed post with AD भी जाता है.
नहीं किया जाए. General 27.
Ordinary process तो होगा ही नहीं सर ना. वेस्ट बंगाल में आपको सर्विस रिपोर्ट नहीं आता है 6 साल तक.
अच्छा.
That is our experience, right? इसलिए वहाँ का नहीं करेंगे.
Registered with AD.
Okay, registered with AD. आप प्लेंटिफ है ना?
जी. Petitioner.
स्पीड पोस्ट से करते तो स्पीड पोस्ट डिलीवरी रिपोर्ट आता है हम लोग के पास, ट्रैकिंग रिपोर्ट. अदरवाइज बहुत दिनों तक आपका नोटिस सर्व नहीं होगा. एडी आता नहीं है लौट के, पता ही रजिस्टर कर देते हैं. जैसा आप बोलेंगे.
Registered. अगर नहीं हो पाएगा तो नेक्स्ट डेट पे मैं फिर उसको
रजिस्टर्ड विद एडी कर देंगे. द रिक्विजिट्स बी फाइल बाय मंडे. Post this case on 25th February, awaiting service.
Item 33, CRNP 3151 of 2024.
But then since CRNP has applied for restoration of criminal revision application which was dismissed for default as the defect pointed out by the section has not been removed within the prescribed time.
We will extend the period for removal of defect.
Yes. And after that, that's maybe.
Defect क्यों नहीं आप remove किए?
Because Lord, the party was living in outside Delhi and he lost his mobile number. He was working as a driver. That is why there was no connection with the party. Only few defects regarding the postal address of the petitioner. Only the same single defect.
मेंटेनेंस का केस है.
Yes.
DFD करके रखे हैं. वहाँ एक्स पार्टी और यहाँ DFD.
Yes. During the corona period, the order was passed.
CRP number 3151 of 2024. This petition has been filed for restoration of criminal revision number 765 of 2023, which stood dismissed on account of non-removal of defects in terms of order dated 22/6/2020. The learned counsel for the petitioner submits that the defects could not be removed on account of the fact that the petitioner lost contact with his advocate. Counsel for the state has no serious objection with regard to prayer for restoration. State has considering the abatements made in the CMP, the time for removal of defects in criminal revision number 765 of 2023 is extended till 24th of January If the defects are removed in the criminal revision within the extended time, office is directed to place the criminal revision before appropriate bench as per Mr. This CRMP is accordingly disposed of.
For hearing under order 41 rules, that is item 34, second appeal 375 of 2016.
Let's playing for not today in this matter.
Sorry?
Playing for not today in this matter.
Rejected. Please argue your case.
Let's say I'm not the conducting counsel in this matter. I got instruction to ticket adjournment.
पहले भी आपको कॉस्ट दे देकर एडजस्टमेंट हुआ है 200 बार. इस बार कितना कॉस्ट देना चाहते?
I'm not like any instruction.
You can't have it both ways, no? The council must have instructed you to seek adjournment.
It may be passed over. I'll get
कुछ क्या ये कितना टाइम्स 10 टाइम्स होगा कि 20 टाइम्स? क्योंकि कोई एडवांस नोटिस आपने नहीं दिया, ठीक है? जिस केस में एडवांस नोटिस नहीं रहेगा एडजर्नमेंट का, हम उसको एडजर्नमेंट नहीं करेंगे और ये 1000 रुपये फाइन नहीं लगाएंगे. द फाइन विल स्टार्ट एट 10,000. इससे कम का कोई फाइन नहीं है. कुछ कराएंगे.
Item 35, second appeal 10 of 2017.
चौबीस चार 2023 चौबीस चार 2023 जिसके सूरत से डिग्री वाज नॉट पेड बाय डायरेक्शन.
एक सेकंड 24/7/2023 को क्या हुआ था इसमें?
Lordship order of the Honorable Court is the Registrar General of the Court is right to supply a copy of the separate file of the interpretation for the report from the principal district of Jharkhand. As to one that what such concept DK has noted there is civil appeal number 10 of 2016 to ensure that the said DK is prepared and the principal district is ready to report this court within 4 weeks from the date of this order without fail. The degree concerned has been prepared.
क्या ही करना है इसमें बताइए. डिग्री तो आ ही गया, इसमें क्या करना है? अब बहस करिए.
Yeah.
Argue your case. You argue your case.
Lordship, in this case also.
What is the substantial question of law?
Partition is well, partition should be filed by the plaintiff lordship, and same by allowed in favor of the plaintiff. Then thereafter, lordship, defendant appellant has filed the partition appeal lordship, and same by allowed in favor of the defendant appellant and remitted back to the concerned court lordship. And then they are
remitted back to the concerned court.
Lordship.
Where is the order of the appeal?
Lordship. And the order of appeal, your lordship, on the ground of the limitation was there, your lordship, 4,136 days, your lordship. On the ground of your lordship, the limitation as per the main petition was dismissed, your lordship. This is the case, your lordship.
No, आपकी बात नहीं समझ आई. The appeal was dismissed.
Appeal was dismissed, your lordship.
On ground of limitation.
On the ground of the limitation, your lordship.
आप defendant हैं.
Lordship, defendant appellant.
So, the limitation has been wrongly condoned.
Lordship, because of the lordship, then after they remand back this matter, your lordship, then the counsel for the
appellate court. After the
appellate court, your lordship, I filed the miscellaneous appeal regarding the because of your lordship, the matter was not had. Order has passed behind the back of the appellant, your lordship. Then after the miscellaneous case has been filed, your lordship. On that miscellaneous case, your lordship, the 2016 तक चलते रहा, your lordship. And when the petitioner has appellant is not, your lordship, then the file also
नहीं आपकी बात में कोई क्लैरिटी नहीं है. फर्स्ट अपील फाइल हुआ, इट वाज बार्ड बाय हाउ मेनी डेज?
first 4,136 days.
4,136 days. ठीक है. डिले कब कंडोन हुआ था?
इसमें delay was not condoned. The limitation petition as well as the main petition by dismissal your lordship on the ground of the bar body of the limitation your lordship.
Where is that order?
Lordship. Page 14 your lordship.
This is order dated 4/10/2016. Okay.
4/10/2016.
Condonation petition was filed, right? Under section 5.
Section 5 and
Yes.
Because of the
Then this
wrong
petition was dismissed.
Lordship, on the ground of the time what it was. I come lordship page 22 your lordship. Thus I find that there is no
Okay, then what happened?
Lordship.
Then what happened? After the petition was dismissed on ground of delay, thereafter what happened?
Because your lordship, this is the partition your lordship, and petitioner has not heard in the first appellate court your lordship. After they remand back the matter your lordship, then you the matter.
Which court remanded the matter?
First title appellate court your lordship.
टाइटल एपीलेट कोर्ट कैसे रिमांड करेगा जब अपील ही बार हो गया बाय लिमिटेशन?
First time your lordship partition should file हुआ. Partition should file होने के बाद in favor of the allow the plaintiff your lordship.
Okay.
Then thereafter if the defendant appellant has challenged before the first appellate court your lordship.
Okay.
And after hearing the appellate court remand back the matter your lordship.
ये condonation of delay किसमें? फर्स्ट अपील में हुआ था?
नहीं इसमें नहीं हुआ. And after the remand.
Civil appeal.
After they remand back the matter your lordship, then that after lordship can lordship the order of the Muncha court your lordship. Partition suit page 70 your lordship. Partition suit number 15/88 your lordship.
Page
70 your lordship. Internal page.
आपका इतना मल्टीपल पेज नंबरिंग है कि क्या ही बोलेंगे?
Page 70 your lordship. Partition suit. Partition suit number 15/88 your lordship.
15/88.
Lordship.
ये रिमांड के बाद का order?
Remand के बाद.
उसके बाद क्या?
Remand के बाद your lordship, I have said in this case your lordship, 15/88 में lordship order was passed your lordship.
Then
And that the net first appellate court has.
फिर फर्स्ट अपील का क्या नंबर पड़ा?
First appeal का number your lordship ये civil 10/2016.
10/2016, right? That first appeal has been dismissed as barred by limitation.
By what limitation?
You are agreed by that order?
Lordship.
First appellate court का कोर्ट के कौन से ऑर्डर से agreed है? That by which it has been held to be barred by limitation.
Barred by limitation on the because of the lordship. After they remand back the matter your lordship, and the dependent appellant has have no knowledge lordship. Then thereafter
Remand आपके बिना सुने हुआ था?
नहीं आप remand back your lordship. लेकिन उसमें फिर नोटिस नहीं हुआ lordship. पिटिशन के appellant dependent appellant के knowledge में नहीं था.
आपका जब मैटर रिमांड हुआ था तब आपको सुन के हुआ था कि आपको बिना सुन के?
नहीं after hearing the matter.
तो आप कैसे बोलेंगे no knowledge?
लॉर्डशिप लेकिन जो आफ्टर द रिमांड द मैटर लॉर्डशिप जो ऑर्डर फिर उसके बाद पास किया गया लॉर्डशिप एक इंडिपेंडेंट अपीलेंट के नॉलेज में नहीं थे लॉर्डशिप.
कैसे हो सकता है? बट आपको सुन के ना रिमांड हुआ मैटर?
रिमांड हुआ है लॉर्डशिप एंड देन देयरआफ्टर जब फर्स्ट टाइम जब रिमांड होने के बाद
वेयर इज द ऑर्डर ऑफ रिमांड?
पेज 70 लॉर्डशिप.
तो पार्टीशन सूट का ऑर्डर है. आपका पेज नंबरिंग आपका बिल्कुल टैली नहीं करता. आपको खुद ही नहीं पता आपका पेज नंबरिंग क्या है. यहाँ तो पेज नंबर 23 है. पेज नंबर 70 बोल के तो कोई पेज नंबर नहीं है.
इंटरनल पेज 23 है. इंटरनल पेज
23 पढ़िए.
दिस इज सूट फॉर
नहीं ये आपका नहीं टैली कर. आपका नहीं टैली कर रहा है इंटरनल पेज 23. आपका पेज नंबर नहीं टैली कर रहा है. इनको एक पेंसिल दीजिए तो नंबरिंग करके दीजिए. आप पेज नंबरिंग करिए बैठ के. एक पेंसिल दीजिए इनको रेड कलर, एकदम एग्जैक्ट अपने रिकॉर्ड से टैली करिएगा नंबर. रेड टाइम सीट पर पेंसिल दे दीजिए. Okay.
Item 36, second appeal 324 of 2018.
This is plaintiff's second appeal against judgment of reversal.
Partition suit.
Pardon?
Isn't it a partition suit? No.
No. Suit for declaration and eviction of defendant. Recovery of partitions.
Suit for eviction.
Suit for declaration and ejection of defendants from the suit land and house.
Let us see the title suit order
At page 30.
at page 30. For recovery of possession.
For recovery.
Declaration तो नहीं. Only for recovery of
Only
possession.
for recovery, since title is mine.
Yes.
I am the purchaser of the property, saying it is standing in my name. Suit was decreed, but the appellate court, on the ground that one eviction suit is pending, has dismissed the appeal, has allowed the appeal, since both matters cannot run together.
The suit was decreed.
What happened was that one eviction suit was earlier filed. Subsequent thereto, withdrawal petition filed in the eviction suit, and thereafter this suit was filed. Suit for ejectment under TPA. Suit was decreed, but the appellate court, during since the matter was pending, eviction suit was pending, held that two matters cannot run together. That is para 19 of the appellate.
So one eviction under the TP Act, another under the regular
TP Act. One under eviction suit, BBC Act, and one under TP Act. This is the finding of the trial court in para 19 at page 24. May I read it?
Yes, please.
May I take help of the friend?
Yes.
Since the matter is very.
No, it's
very 19.
Paragraph 19. At the time of impugned judgment, title eviction suit of plaintiff respondent bearing title eviction suit number 49 of 2002 was still pending, which was filed by the plaintiff respondent against the defendant number 1 for recovery and eviction of suit property on the ground of default of payment of rent. And here also, in this case, in the deposition of PW1, this plaintiff respondent has stated that defendant number 1 was in his house on the rent, and during examination in chief, PW1, this plaintiff respondent himself has not stated specifically that on what capacity defendants appellants are in possession, either as renter and as a permissive possession or gratuitous licensees. So still the plaintiff respondent is in confusion that on what ground he has filed the recovery of possession, whether on ground of default of payment of rent as a renter by defendant number 1 or as permissive possession of the defendant, and these are two contrary grounds. At the time of impugned judgment, another suit of the plaintiff respondent, title suit 49/2002, was pending for eviction of the defendant on the ground of default of payment of rent, and still this suit has been filed and judgment has been pronounced by the learned trial board. And in this suit, the plaintiff has filed for recovery of suit property from possession of defendant on the ground of permissive possession or gratuitous licensing. So when a case of eviction has been pending in the court on the different ground for default of payment of rent, then this suit has been filed on contrary ground and the different ground for recovery of possession, that the defendants are permissive possession or gratuitous licensing, which is totally different ground. One cannot file two suits simultaneously for different ground for recovery of possession. Hence, in this case, plaintiff has filed simultaneously two cases for recovery of possession against the defendant. One is for default of rent by the defendant number one as a tenant, and other ground on the ground of permissive possession or gratuitous licensing. So, two suits on different grounds of recovery of possession simultaneously cannot be maintainable because it is still confusion that the defendants are on what capacity in permissive possession of the suit land, whether defendants are in permissive possession or gratuitous licensee or as a renter. It is incumbent upon the plaintiff to prove his case on definite grounds, but the plaintiff is totally confused whether the defendant.
My submission is that we have filed an application, interlocutory application, being IA number 9077 of 2023 under order 41 rule 27 of CPC, bringing the entire order sheet of eviction suit which was withdrawn by the order dated 1/7/2009. That eviction suit, in the earlier eviction suit, we had filed an application for withdrawal, but no order was found.
So?
That may have brought to the knowledge of this honorable court.
That is not sufficient. You have withdrawn it ultimately. No order has been passed.
That has been withdrawn.
Withdrawn means what? Where is the order of withdrawal? And on the time, at the time when the first appeal and when the this particular suit was decreed, at that time it was withdrawn.
Yes. It was withdrawn on 1/7/2009.
Where is the order of withdrawal?
Order of this court to file.
Order of withdrawal. Permitting withdrawal.
Yes. That is what I am submitting. IA number 9077 of 2023. The last page, page 34.
Yes.
तो हिंदी भी लिखा और पढ़ देते।
तो ये ऑर्डर आपने टाइटल सूट में क्यों नहीं फाइल किया?
नीचे कोर्ट में नहीं फाइल किया था।
क्यों नहीं फाइल किया?
तो हम बताते हैं, नीचे कोर्ट में अपीलेट कोर्ट के पहले यह ऑर्डर हो चुका था 2009 में ही, बट ड्यू टू रॉन्ग एडवाइस और समथिंग, अब उसी ग्राउंड पर अपीलेट कोर्ट अपील डिसमिस कर दिया। देन वी आर फोर्स्ड टू फाइल दिस एप्लीकेशन।
तो ये क्या है आपका? एडिशनल एविडेंस फाइल कर रहे हैं क्या?
हाँ, एडिशनल एविडेंस है, ऑर्डर 4127।
एडिशनल एविडेंस का क्या प्रिंसिपल?
Since the evidence was, this fact was not brought to the court, knowledge of the court.
It was your suit you had withdrawn, isn't it? It was your suit only which you had withdrawn?
Yes, certainly. Certainly, wrong advice or they say laches on behalf of the athlete.
आप फ्रेश सूट फाइल कर दीजिए, इसमें क्या ही दिक्कत है?
Then again it will take years together.
ऐसे नहीं हो सकता।
We have brought it on.
Substantial question of law बताइए।
B and C है मेरा ground में दिया।
ऐसे कैसे हो सकता है? बताइए, आप लोगों को बताइए ऐसे कैसे हो सकता है? आप अपना फ्रेश सूट फाइल करिए, you have a fresh cause of action. What a fresh or whatever, indicating that you have already withdrawn the suit. Additional evidence के purview में ये कैसे आएगा? At the second appellate stage, you want to adduce it as an additional evidence.
Since prior to that, we had entitled suit, decision of judgment of title suit.
So therefore, you have to satisfy the court. What prevented you to bring this fact to the notice of the trial court, notice of the appellate court?
This was not the reason of the judgment of title suit. In appellate judgment, this reason was assigned.
They must have raised this reason, na? They must have raised this point. I'm sure they must have raised this point.
Raise to किए थे, but the trial court did not take अभी पढ़ देते.
भाई appellate court में तो raise किए ना इस point.
Appellate court में अगला raise किया, and the court took note of that. बोला two cases simultaneously cannot run. For eviction or rejectment of the.
ऐसे नहीं होगा ना. Merely because you have been, you see, a suit has been filed. The suit has been ultimately withdrawn. Merely because the suit has been withdrawn, the same does not mean that the concerned person was not a tenant.
That is true.
Then under such circumstances, he will have a right to plead that no, I am a tenant, I am not a licensee. There are so many intricate things which are involved. ऐसा इस circumstances में इस particular document को लेकर हम क्या ही यहाँ पे decide करें?
That very plea was taken by them.
तो अब तो फिर खाली उससे नहीं ना होगा सर. There are so many things involved. The status of the parties are involved in this case. इसमें तो आपको fresh trial में जाना ही पड़ेगा.
And the law.
Correct. Second appeal number 324 of 2018 with IA number.
Remember one thing. While filing title suit number 123 of 2009, out of which this second appeal arises, in para 20 we have categorically stated that in view of the above circumstances,
that in view of the above circumstances, the plaintiff was advised to file present suit for recovery of possession of Schedule B from the defendant number 1, treating him as gratuitous licensee. For withdrawal of title eviction suit number 49/2002, plaintiff had already filed withdrawal petition, but defendant number 1 with malified motive to delay the present filing of present suit has not filed rejoinder to the plaintiff's withdrawal petition.
That's right, you said so, but you said so that you have filed it, but the fact that it was withdrawn was not brought to the notice of the
they
court.
did not file rejoinder. There would be a delay occurred.
No, maybe whatever it is. You
And
see, the status of the party is required to be determined. That will be determined in the fresh suit. We do not know. There could be, you see, there could be a situation where the plaint and written statement has been filed in the eviction suit where you admit the status of each other. We do not know.
We do not.
There may be many things. The status quo the parties is required to be determined. This particular interlocutory application will not cut much ice. But certainly now since that has to be withdrawn, then you may have, you have to, the liberty is always there with you to proceed in accordance with law. But that particular additional evidence cannot be brought on record in this particular second, isn't it? देखिए essay number 324 of 2018 with IA number 9077 of 2023. The learned counsel for the appellant has submitted that the matter arises out of title suit number 123 of 2009 seeking recovery of possession of the suit property the plaintiff had asserted that the defendant was in permissive possession of the suit.
Because all are brothers.
Yes. The suit was decreed by the court. The defendants filed civil appeal number 66 of 2017 and the decree in the title suit has been set aside on the ground that the title eviction suit number 49 of 2002 filed by the plaintiff against the defendants was pending, and therefore the stand taken by the plaintiff in the title eviction suit number 49 of 2002 seeking eviction under the building control laws on the ground of default in payment of rent was inconsistent with the plea raised by the plaintiff in the title suit, asserting that the defendants were in permissive possession of the suit property. The learned counsel submits that a plea was raised before the learned trial court in the plaint itself that a petition was filed seeking withdrawal of the title eviction suit, but the same was not yet withdrawn as the defendants had not filed their response to that application in the title eviction suit. And in the present case, one interlocutory application being number 9077 of 2023 has been filed seeking to adduce additional evidence before this court by stating that the title eviction suit was permitted to be withdrawn while order dated 1/7/2009, which was certainly after the filing of the suit.
I mean, permitted to clear the situation. The suit was filed. Suit का judgment was 6th day of June 2017.
Oh, the suit was withdrawn after
this suit was
the eviction suit. The eviction suit.
Eviction suit was withdrawn on
1/7/2009.
1/7/2009.
2009, which was certainly after the filing of the present suit.
Yes. That is true. But the application was filed earlier.
Yes.
एक पैरा जो है जजमेंट का अपील के जजमेंट का पैरा 19 एट द टाइम ऑफ इम्प्यूग्ड जजमेंट मतलब टाइटल सूट के जजमेंट टाइटल इविक्शन सूट ऑफ द प्लेंटिफ रेस्पोंडेंट बेयरिंग टाइटल इविक्शन सूट नंबर 49 of 2002 was still pending, which was filed by plaintiff respondent against the defendant number 121 for recovery of eviction. तारीख जो है वो इम्पोर्टेंट है, उस समय तक तो विड्रॉ हो चुका था.
The learned counsel has submitted that in the impugned judgment passed by the first appellate court, it has been recorded that at the time of passing of the judgment in the title suit, the title eviction suit filed by the plaintiff bearing title eviction suit number 49 of 2002 was still pending. The learned counsel submits that the interlocutory application seeking additional evidence revealed that the title eviction suit was withdrawn on 1/7/2009. However, during the course of hearing, it is not in dispute that the order regarding withdrawal of title eviction suit was not brought on record before the learned first appellate court, and consequently the appellant is seeking to press the interlocutory application C for additional evidence before the second appellate court. After hearing the learned counsel for the appellant and going through the interlocutory application seeking to give additional evidence at first appellate stage, this court finds that it is not in dispute that when title suit number 123 of 2009 was filed on 5th of May 2009, the eviction suit number 49 of 2002 was pending. And the eviction suit was decreed only on 15/6/2017. The interlocutory application also revealed that against ये writ क्या था? Writ against withdrawal. WPC number 6105 of 2004. It appears from paragraph 2 of the interlocutory application that against the withdrawal of title eviction suit number 49 of 2002, the present respondent had preferred a writ petition, being WPC number 6105 of 2004, which was also dismissed as withdrawn. However, as per the case of the appellant, the eviction suit stood withdrawn on 1/7/2009, which was neither brought to the notice of the trial court by filing any application or petition, or even during the course of evidence, nor the same was brought before the first appellate court by filing any additional evidence, and consequently the first appellate court has observed that both the title eviction suit and the suit filed seeking eviction on the basis of permissive possession could not go simultaneously and held that the suit was not continued. This court finds from the interlocutory application that no reason has been assigned for not bringing the order of withdrawal of the title eviction suit before the learned trial court or even before the learned appellate court. In such circumstances, this court is not inclined to allow the interlocutory application seeking additional evidence before this court. However, so far as the impugned judgment is concerned, no substantial question of law as such has been pointed out by the learned counsel appearing on behalf of the appellant. And accordingly, the present second appeal is hereby dismissed. It is sufficient to observe that if the appellant has any other cause of action, the appellant may avail the same in accordance with law and as may be permissible under law, subject to any objection that may be raised by the defendant. इतना काफी this appeal is hereby dismissed.
Item 37, second appeal 337 of 2018.
Yes. Next week. क्या ही है इसमें next week करने? बताइए. डिले आपका कंडोन हो गया, उसके बाद कॉस्ट दे दे के आप अपना एडजस्टमेंट करा.
Till next week में रखेंगे.
आपको पता है पुराने कोर्ट में there was a rule, है ना? अब बस एक सुनना जुट गया. नहीं हो, ऐसे नहीं होगा. अब इस तरह से सेकेंड अपील नहीं हो जाए. 2018 का सेकेंड अपील.
Next week में हम लोग करेंगे.
अभी तो नेक्स्ट वीक कुछ नहीं. शुरू करिए, बुलाइए उनको. कहाँ?
कोर्ट नंबर 13 में.
हाँ कोई बात नहीं, लेक्स है ना, उनको बुलाइए. ऐसे नहीं हो.
पास ओवर कर दिया.
हाँ पास ओवर कर.
Item 38, second appeal 338 of 2018.
Respondent number 16 has died. A substitution petition needs to be filed.
Respondent number 16 has died.
Yes, ma'am.
When did he die?
29/10/2024.
अबेट कर दिया ना?
90 days time होता है for substitution.
29/10. अच्छा, ठीक. Second appeal 338 of 2018. The counsel for the appellant submits that the respondent number 16 has expired on 29/10/2024. He seeks adjournment. तो कब रख दे बताइए?
After 29th of January, after 90 days.
Pose this case on 4th of February under the heading for orders.
Okay.
90 days होता है, दिन काउंट कर लीजिएगा.
90 days.
31 दिन दिसंबर है, 31 दिन जनवरी है. Take care, you have to file it, na?
Yes.
Take care. This is what I'm saying.
Yes, ma'am.
अच्छा है, जब फाइल करना है ये तो पहले ही करेंगे ना?
जरूर. Okay.
Item 39, second appeal 361 of 2018.
This is a matter where the title suit was in my favor, the applicant's favor, and there is a reversal judgment in the first appeal. So now it is the second appeal.
You are the plaintiff.
Plaintiff. This title suit, partition
was
suit
the-
judgment is of page 49 itself.
Page 49. Where are the issues framed?
It's yet to 41 to 11 hearing. Issues frame at page 53, sir. Internal page is 5. Issues frame at page 53.
What are the points of determination where the appellate court?
Determination, only one humble indication before going deep into the facts of the matter. The issue number 8,
Yes.
whether the partition took place amongst the descendants of Jiblal after his death. Now, these plaintiffs are the descendants of Jiblal Malik. Now, in this matter, the defendants WS, their averment was that there is a previous partition after the death of Jiblal Malik. So, there is a stand taken by the defendant concerned. There was a previous partition only, and therefore, this separately acquired property of Ram Ratan Mali being a Karta, he was not Karta, that is the son of Jiblal Mali. So therefore, my father's property is separate acquired property, therefore there is no partition can be done with these plaintiffs, that is the appellant here. So
they were not in jointness.
So their claim is there. Now only one humble indication to leadership is this. This issue has been decided properly in the partition suit judgment. Now how it has been reversed, only one line I just wanted to show that will suffice the entire purpose of today's hearing. The leadership may have the first appellate court order and page 31 before the last paragraph, last 3 lines below, is 31. Internal page is 31 of the title appeal judgment. Page 45 is the relevant running page.
Read it, please.
So it says, the last portion says, although there is no clear evidence to show division of ancestral property left by the common ancestors by meets and bounds. Now this is the finding the court itself, title appellate court has accepted.
You just read it from here. I do not find any reason.
Well, I do not find any reason to confirm the findings and decision of lower court on the issue number 6 and 8 to the extent that at the time of execution of the exclusion of the suit property, Ram Ratan Mali, being the eldest son of the family, was the Karta of the joint family, and no partition took place amongst the descendants of the common ancestor till that time. However, I have no hesitation to hold herein that sometimes after the execution of the suit property, before filing of the suit, the joint status of the family of the suit severed, and all the brothers of common ancestor constructed their residential house by their own income and on the ancestral land, and the same amounts to partition in Mitakshara sense, although there is no clear evidence to show division of the ancestral property left by the common ancestor by the meets and bounds. Now what the error has been committed further, leadership may see. Page 26 it will reflect. Now the settled position of law is that once the suit is framed, so according to that, the title appeal court has to test the matter if at all in the appellate side. Page 26 may be seen, Roman 2, 15, para 15, Roman 2. Now here a fresh issue has been rather framed. It says whether the joint family had nucleus of joint family income, much less sufficient one, or had joint family fund from the income.
Para number 26.
No, page number 26, running page is 26, internal page is 12 of the title appeal judgment. My petitions, page 26.
The pages does not tally. Internal page 12.
Page 12, it should have title appeal judgment, internal page 12, para 15, Roman 2. It says whether the joint family had nucleus of joint family income, much less sufficient one, or had joint family fund from the income,
of ancestral property or by joint labor, out of which the suit property could have been acquired, or same was self-acquired property of the predecessor in interest of the appellants. Now this issue, rather it has cropped in for the first time in the appellate side, the court has framed this issue. Now
Is there any bar?
Yes,
Point of determination can be framed. Is it necessary that it has to be the same as one of those of the issues?
The issue, once the appellate court has to test issue number 8, which I read just now, if the court itself is accepting that there is no clear evidence on that area,
But that is a separate.
so the determination toward that, if adding some extra facts for the determination, whether there is a jointness of the property or not, or maybe the funds have been into
That
one
will,
purpose.
whether the property was joint family or not, would ultimately depend upon the nucleus in the family, isn't it?
Let's say I just indicate in this matter, I'll just give you the brief facts also. Once the Jiblal Manji died, the partition was never taken place as it is at the stand of the plaintiff. They say there was a verbal partition by Mitch and Bond, therefore people are living separately, having a separate kitchen. Now it is admitted position, this appellant, first appellant was into a job in other place, West Bengal, and the Ram Ratan Mali, who happens to be the Karta of the family, that is the defendant's father, he was working at Bukar. So that argument they are taking, since they are living separately, and despite the fact there are various evidences in the title suit partition suit judgment itself, correspondence of the letters, even the appellant has sent money to the elder brother for the purpose of.
There is no other evidence of, as per the finding of the appellate court itself, there is no clear evidence.
Once the onus has been shifted, if they claim there is a previous partition already been done, so they have to come up with that. If there is
The
no
plaintiff was claiming previous partition.
No, the defendant.
The defendant was claiming previous partition. Are you for the respondent in this case? Records have been received?
They appeared in for limitation purpose.
For limitation. Say एक ही बार. Records have been received? No, records have not been called so far. What is the question of law according to you? Which question of law are you referring?
Perhaps my friend is not aware, the delay has already been condoned by order dated 28 February 2023. He says he is appearing for the limitation. But the question would be, because once the
You have raised, you have framed the questions. You
Well,
tell us which question are you referring to?
the Roman 6. Whether the learned court below failed to appreciate the evidence that the suit properties were acquired from joint family fund in the name of Ram Ratan.
From where do you get this?
So
With
I
your
just-
family fund? Which evidence?
I just show it. Now, the exhibit 1 in this matter is the certificate given by the postmaster department, where it has been certified that I used to send money to my elder brother. So that judgment, the judgment of the partition suit may be seen for a while.
You see,
Series
you
of-
might be sending money to your elder brother, but is there any evidence that you sent the money to your elder brother to purchase a property?
So that no, the conduct of the parties of the has to be seen in the family. So that will come up from the running page of.
Just let us see the trial court decree judgment regarding jointness of property. Let's have a look at it. Issue number 8,
Yes.
right?
Yes.
What is the finding with regard to issue number 8?
So issue number 8 is at page 60 and internal page is 12, para 10 of the judgment.
That's right. It starts from there. Yes.
Supporting the
In
case
view of the discussion, I find that. Can you read this?
Let's see the title.
Page 63, internal page 15.
Issue 5 and 7. 8 is at
No, the finding, the ultimate finding of issue number 8.
para 10.
Just above, yes, para 10, I'm at the end of para 10.
Fine.
In view of the discussions, read it please. Could you get it just above para 11?
Yes. In view of the discussion, I find mere plea is not enough to prove the previous partition on the basis of some oral evidences on separate mess and residence when case has been pleaded by for partition by meets and bounds, and thus I hold the defendant have failed to discharge the onus to prove previous partition, and the issue number 8 is accordingly decided against the defendant in favor of the plaintiff.
So therefore, there is a finding given by the learned trial court that there is no evidence of previous partition. Now, so far as the appellate court is concerned, appellate court also records a finding that there is no clear evidence of previous partition. So there is a concurrent finding that there is no clear evidence of previous partition. So your contention and point of law could be that on account of this clear finding by both the courts, whether the partition could still be denied.
Yes, ma'am.
Right? And after having held that there is no clear evidence, the learned appellate court has still refused partition on the ground that they were living separately on the ancestral properties and were separate in mess and had constructed separate houses for themselves. इतना से हो जाएगा? आप बताइए. Separate mess and construction of separate houses on ancestral property is sufficient to prove previous partition.
Yes, yes.
How? And the appellate court is also recording that there is no clear evidence of previous partition. Mutation हुआ किसी का?
नहीं.
बात करते हैं. Still joint.
This only.
You have to say something?
There's only one judgment is wanted to court. This is a 1968 SSC online SC 134 1967. Para 4 may be seen that will suffice the purpose and answer this query. Since it's a property acquired after the death of the original Karta, that is Jiblan Mali. Now, he being the father, the descendants of Ram Ratan Mali. Now, Para 4 says the general doctrine of Hindu law is that property acquired by a Karta or a co-partner with the aid or assistance of joint family assets is impressed with the character of joint family property. To put it differently, it is an essential feature of self-acquired property that it should have been acquired without assistance or aid of the joint family property. The test of self-acquisition by Karta or co-partner is that it should be without detriment to the ancestral estate. It is therefore clear that before an acquisition can be claimed to be a separate property, it must be shown that it was made without any aid or assistance from the ancestral or joint family property. It is their own stand contradictory to saying that if they once say it is a separate acquired property, therefore it is their property. On the other hand, say they say there was already a partition taken place. Now, once the concurrent finding with respect to that, there is no evidence as such. So, appellate court had said it is no clear-cut evidence, but then the trial court has correctly held that once the claim owners has shifted and the burden shifted towards the defendant to prove the previous partition by means and bounds, there is no evidence as such. So, whether it is clear or not.
So, in absence of any clear evidence on the point of partition, it was for the defendants to prove that it was their self-acquired.
Yes, if they have taken that stand in the government, and to that effect, they have never laid any evidence to that effect also. And even the trial court order, page 10 onwards, various letter conversations have been recorded in Hindi also, which is going to show that how the brothers are concerned for each other's family and development of the family, and how their jointness of the ancestral properties.
Second appeal number 361 of 2018. The learned counsel for the parties are present. The learned counsel for the appellant has submitted that the suit was filed for preliminary decree for partition to the extent of 5/6th share in favor of the plaintiffs. The property details was provided in the schedule to the plaintiff. The learned counsel submits that the defendants claimed that a partition had earlier taken place amongst the descendants of Jiglal Mahli after his death, and therefore there was no unity of title and unity of possession. He submits that one of the main issues which were framed by the learned trial court was issue number 8, that is whether any partition took place amongst the descendants of Jiglal Mahli after his death. He submits that this issue was decided in favor of the plaintiff by holding that mere plea was not enough to prove previous partition on the basis of some oral evidences on separate mess and residence. And when the case was pleaded for partition by writs and bonds, the defendants had failed to discharge the owners to prove previous partition. The learned counsel submits that the defendants had filed the appeal and the appellate court held in paragraph. What's the finding?
The finding is at page 31.
At paragraph
Paragraph
13.
43.
At paragraph number 43 of the appellate court judgment, that the appellate court did not find any reason to as held that though there was no clear evidence to show division of ancestral property left by common ancestor by myths and bound, but still the learned appellate court did not find any reason to confirm the decision of the learned trial court on issue number 6 and 8, to the extent that at the time of execution of the suit property, Ram Ratan Mali, being the eldest son of the family, was the karta of the joint family, and no partition took place amongst the descendants of the common ancestor till that time. The learned counsel submits that In absence of any clear evidence to show division of ancestral property, and in absence of any evidence that the property involved in this case was the self-acquired property of the defendants, the learned appellate court was not justified in reversing the decree. यही है आपका? The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that no substantial question of law is involved in the present case. After hearing the learned counsel for the parties and going through the impugned judgments, this court is of the considered view that this appeal is to be heard on the following substantial question. Whether the learned lower appellate court, learned first appellate court is justified in reversing the decree of partition in spite of holding that there was no clear evidence to show division of ancestral property left by the common ancestor by metes and bounds. B. Whether the defendants had discharged their onus with regard to factum of partition and that the property was their self-acquired property. उन्होंने claim किया था self-acquired property?
Yes.
इसमें कोई finding नहीं है appellate court का.
With respect to the self-acquired property, the admitted fact is this: after the death, 1969 and 70, the purchasing of that property happened. 1966, the father died, that is Jibla Khan. So after 4 years of the death of the father, he purchased the property in his name. And he was a karta, and the exhibits 1 and onwards is there with the corresponding between the brothers.
Second question of law would be required.
But my only request, if I impress upon with respect to the point of determination, or it is a framework for new issue. That judgment I just got. If you issue a comment, I can show. Or maybe it's for some other purpose. Just if I can please. This is judgment passed by Honorable Mrs. Justice Neela Trivedi. In this matter also the suit was framed and title suit was in favor of the plaintiff, and ladyship may see the relevant point of law is at para 12, para 11 and 12 onwards. Says, it is needless to say that order 41 of the CPC would apply to the appeals from the appellate's decree also, as contemplated in Rule 1 of Order 42 of the said court. As per Order 41, Rule 25, the appellate court may, if necessary, frame issues and refer the same for trial to the court whose decree is appealed from, and direct such court to take additional evidence required. Further, as per the Rule 27 of Order 41, the appellate court may allow evidence or document to be produced or witness examined in the circumstances stated there.
No, I just want to know whether these two issues will suffice your purpose.
Because once the issue number 8 is in my favor, then it will suffice the purpose of it. If the partition never happens, what they claim? Then on the very first day, they are not saying that it is a self-acquired property. First, they claim it should be.
You say that there is no evidence.
They have never.
Did they take a stand in the written statement that it is their self-acquired property?
It's an admitted position in the name of the Ram Ratan Mali, the property was purchased. So therefore, their claim is it is a separate acquired property, and since partition already been done, so therefore it will be termed as a separate acquired property. That is their claim.
That is their case. Otherwise, so issue number 1 would be sufficient.
That will suffice only for the reason once they accept that there is a previous partition, therefore it will be termed as a separate. And once there is no previous partition, if I prove, so that it will suffice the purpose.
No, that will not suffice the purpose because the property stands purchased in the name of a person, right? Merely because the property stands in the name of a person, that will automatically not become a joint family.
So being a question of law is involved, whether
Therefore, the second question be also there. You can say that there is no evidence to that. Have they laid any evidence to that effect that it was their self-acquired property?
The question of law whether in the capacity of Karta he has purchased or not. So that finding is there with respect to the.
We'll see that. Let these 2 points be there. This has not been admitted so far.
No.
Call for the records from the concerned court. कब करेंगे बताइए?
This one is in question.
Pose this case on Sixth of March, awaiting the records from the concerned court under appropriate. ऐसा कुछ सप्लीमेंट्री बोल के नहीं फिक्स कर रहे हैं, मेंशन करेंगे तो कर देंगे.